Right. Okay, so let us yes, march onwards. Appeals. So again, I've tried to pull together. I think this is going to click onto the next slide. Yes, tried to pull together the various enactments of different shapes and sizes from Chapter 10. But yeah, so in terms of appeals processes, we'll just kind of work through those till we get to the end. There is one I have to say that is kind of missed off of that shopping list in 10.1. This chapter was, the adjunct was Gordon Dawes, and Gordon was very keen that we added something about the royal prerogative of mercy. I can't imagine that crops up very often in practice.
Well, I must admit, it's surprised me by
Yes, the plea, yes. But anyway, so that's the last thing that we're going to be considering from this chapter anyway. Okay, so appeals from magistrates to the Royal Court sitting as the full court. So you can see the relevant laws set out there at 10.2, and it says once the Magistrates' Court has heard and determined a criminal matter, then there's a right of appeal to the Royal Court by either a defendant against conviction or sentence or both, or by the prosecution against an acquittal. Okay. Prosecution can't appeal unless it successfully applies for a certificate that the contested question arose that it would be desirable for the Royal Court to determine. And that might be a pure question of law or mixed law in fact. And to that extent, I suppose this is slightly unusual because generally speaking, with appeals, criminal appeals, if it's a pure question of law, you wouldn't usually, in other systems anyway, require leave or a certificate or anything like that. But anyway, you do, so there we are. Yes, okay. What did I want to think about that? All right. You can see from footnote 797 that these provisions also apply to appeals from the Juvenile Court, because of course the Juvenile Court is just a specific type of Magistrates' Court as far as jurisdiction is concerned. So similar provisions apply. And just as a small note on that point, there's a case which we've already encountered, I think this morning and at other points across either this weekend or our previous weekend. So there's a case of X against the law officers in 2013. You can see there the relevant provision is section, bless you, 5 sub 4 of the Criminal Justice Children and Juvenile Court Reform, which we were looking at this morning, law of 2008. And that says the provisions of the Magistrates' Court Criminal Appeals Guernsey Law 1988 should apply to and in respect of appeals from the Juvenile Court in the same way as the provisions apply to appeals from the Magistrates' Court. So they are effectively identical to each other. However, we need to note that under section 2 of the Criminal Appeals Guernsey Law 1988, it does say that, we'll look at this in a bit more detail in a moment anyway, but no right of appeal should arise under this law, and there are a number of situations where no right of appeal does arise. And the fourth and final one, D, is against the conviction of any person if the punishment awarded in respect of such conviction does not exceed one or more of the penalties mentioned in section 2(1)(c) above, unless you can get a certificate from the court. And this is kind of coming back to that observation that Mark made on our previous weekend about the magistrate who used to sentence people to multiple 7-day sentences because that would not be appealable. Okay. In this particular example, the X case from 2013, X was a juvenile and had been dealt with in the Juvenile Court and was appealing to the Royal Court. The sentence that had been imposed on him was a supervision order, okay, which didn't appear in the list of sentences that one had to exceed in order to be able to appeal. Okay, and I think frankly that could have gone either way, really. But what the Royal Court actually said there was that the absence, I think it was the deputy bailiff, the absence of supervision order from that list didn't mean that you had, didn't mean that you could not appeal. What it meant was that you could appeal and you didn't need a certificate or anything at all, because it just fell outside of those kind of limitations on when you could appeal, and it wasn't on that list, so you just appealed at the end. So happy days as far as Mr. X was concerned. All right, so restrictions, that's basically what X was kind of considering there. So as you can see, defendant who pleads guilty has no right to appeal against conviction, but there may be exceptional circumstances where the court may give leave to appeal. Let's just bring up the case of Townsend. So yes, as you can see then, only to be allowed where you've pleaded guilty but you want to appeal against conviction for fairly obvious reasons. Only to be allowed in exceptional circumstances, that's what the law says. Only to be allowed where later evidence showed clearly that the basis on which a guilty plea had been tendered was wrong, or there was some other exceptional matter. Applying an English case from 1923, where the defendant Ford had pleaded guilty, it was said that a plea against conviction could only be entertained if it appeared the appellant did not appreciate the nature of the charge, or did not intend to admit that he was guilty of it, or that upon the admitted facts he could not in law have been convicted of the offence charged. So quite limited, and I think it's fair to say that those, although they're fairly elderly, 1923, nearly a century ago now, I was teaching exactly those points to the bar students just last week, in fact, so the same principles are still in operation. Right to appeal against sentence, we can see there then this is where those provisions are coming in. No right to appeal against sentence where that sentence was for 7 days imprisonment or less. Fine not exceeding level 2, which is currently £1,000. Compensation has been ordered up to £75, or confiscation of goods up to a value of £75, or suspension of any licence or permit for a period not exceeding 7 days. So essentially what you've got then is kind of like a de minimis system in operation there. And also, although that's specifically referred to appeal against sentences, you can see where one of those sentences is imposed there, there's no right to appeal against conviction either, unless you can get a certificate from the magistrate's court. Yes, all right, so you've got a bit more detail in 10.5 as far as Townsend is concerned. I don't know that it's particularly necessary to read Townsend, although it's a fairly short report in the Guernsey Law Journal. It's an interesting little read, I suppose. Mr. Townsend, according to him at least, was off his head on various illicit substances, and I think alcohol as well, at the time that he committed the offences, and subsequently, I think when he turned up to the Court of Alderney, said he didn't understand what he was doing, and felt that he'd been put under undue pressure. But neither the Court of Alderney nor the Royal Court was persuaded that that constituted an exceptional circumstance. Just an interesting conclusion to come to. Anyway. Maybe not exceptional in terms of the clientele that are coming before the courts, but you might raise an issue around what, fitness to participate then. But anyway. Oh, I think he did. Yes.
Where one of, I think it was Hatwell, driven himself to court, being convicted, given a suspended sentence, somewhat mercifully, told not to drive because his licence had been suspended, and then drove along Port Road and got nabbed and ended up in prison. But he was assessed as having thought, there were no readings or anything, but I think he was probably drunk at court.
Bonkers.
Well, if you think your client is drunk, you have to do something about it. You can't allow them to appear if they're not fit. In the same way as you need to, although it's the prosecutor's job providing interpreting, you need to be the person flagging it up if it hasn't been noticed.
Yeah. Yes, I see two guys were, I think, convicted just last week, actually, of setting up a fake agency to provide interpreters and then claiming like payments back from legal aid. They made quite a bit of money, actually, but they're now being entertained at Her Majesty's pleasure. Yes. Anyway, and 10.6, you have our old friend X appear again. So there's just a little bit more kind of flesh on the bones there, but I don't think we need to detain ourselves any further with that, except perhaps, yeah, maybe perhaps there, just this kind of passing reference at the end of that passage, at the bottom of 179 onto page 180. Not necessary to resolve the issue in this case. I think it must remain an open question as to whether removing the right to appeal against conviction in the way that section 2.1d does, in other words, limiting it to the sentence that's been passed, can be regarded as HR compatible. But that wasn't determined there, and I haven't found anything where that has been revisited either. So it was flagged up and it's now gone back to sleep again. Notice of appeal then, as you can see, must be given to the greffier within 14 days after the date on which the relevant decision was taken, which I am reading means that if you're appealing against conviction within 14 days of conviction, and if you're appealing against sentence within 14 days of sentence. Although that's an extendable time limit, so maybe it's not that significant anyway.
A suspended sentence, you might decide to, you could either put it in and then withdraw it, or apply extensions after sentence, or apply retrospectively. The jurisdiction is fairly benign on those points, I would say.
Yeah, I have to say that probably one of the most frustrating meetings with a client that I had was when we were in the magistrates' court. I think it was a driving offence, if memory serves me correctly. I had made it was early days of practice. I'd made what I thought was a particularly well constructed and well presented series of legal arguments with copious reference to Wilkinson's road traffic law and Stone's Justice's Manual. And the magistrates retired for, I think, all of about 5 minutes. I mean, long enough to kind of get outside, maybe decide, have a cup of tea or whatever, comfort break, and then go, right, we all agreed, and then come back. I mean, they couldn't even have looked at the references that I gave, found them, let alone actually digested them at all. So they were out for 5 minutes, came back and convicted. I was outraged, absolutely flabbergasted by this disgraceful behaviour. Anyway, they moved on to sentence, and I think he got a £300 fine. So no, when I got him outside the court, I said, right, so we'll appeal your conviction to the Crown Court. It'll be fine. I'm convinced, 100% convinced that we'll be successful. He said, yeah, it was only 300 quid, wasn't it? Yeah, but never mind, you shouldn't have been convicted. The law is on your side. He said, no, I just paid the 300. No, you must appeal against the conviction. The law must be upheld. No, I just paid the 300 quid, forget about it. But anyway, yeah, so sometimes, yeah, as you say, when they find out what the sentence is, it just dies a natural death at that point, yes. Despite our best endeavours. All right, after notice has been supplied, as you can see, greffier obtains 15 copies. I mean, frankly, this seems to me a tad excessive, but that's what it says. 15 copies of the transcript of proceedings as soon as it's reasonably practical. Well, I'm glad to hear it. Yeah.
I'm pretty sure he doesn't. I mean, what would you well, I said you need to have copies for the jurors.
Well, we
can
can find the kind of paper trail here. So what have we got? 2 copies to the procurer, 13 to the bailiff secretary. I don't know what he or she's doing with them. Yeah. 3 certified copies of the Act are obtained as well, but that makes much more sense to me. But anyway, no, all right, that's good. It's a relief. So once the bailiff's secretary has received all these multiple copies of the transcript, then a date for the hearing is set down. Procurator is notified, then summonses the other party to the appeal to appear. And that's basically that. So effective giving notice of appeal, as it says, the sentence may be suspended until the appeal is disposed of, but not necessarily. It's not an automatic thing. So the magistrate's court may refuse to suspend a sentence of imprisonment, in which case the defence may apply for an order suspending it. Yeah, because it may be the magistrate's court the sentence is sufficiently short, whilst being in excess of the 7 days, sufficiently short that you're probably going to have served it by the time the appeal hearing comes on.
That frequently happens, and happens and so as soon as that's been an issue, they will suspend the sentence.
Yeah. Okay, so other things to think about. Well, as you see, it may be that there's an order for confiscation of goods or suspending or withdrawing a driving licence. So the goods or the licence affected must be handed over to the greffier to be kept safe pending the outcome. So there you go. Bail pending appeal, kind of related to what we were just talking about there, I guess, where the appellant is in custody, may be released on bail by the magistrate's court. And if he is to be released on bail, he has to do the following things. Yeah. And I don't think there's anything in particular that we need to pick up on that. Maybe the last bullet point is an interesting one. If required to do so by the court, take an oath to remain within the jurisdiction until the appeal is disposed of, and that he will attend the appeal hearing. And you can see that there are penal sanctions to ensure compliance with that. Legal aid, we've mentioned legal aid from time to time. Yes,
I'm not sure it's done this way.
No.
And I will do that in
what, the oath thing?
I think that legal aid is done through the legal aid service. I don't think it's done this way. In fact,
okay, all right.
they may not have included provisions. I will double check.
Right.
But I think it's unlikely to come up as a question, to be honest.
No, all right, well, maybe we'll pass on from that then. Grounds of appeal. The relevant law from 1988 doesn't provide any grounds of appeal. And basically the situation that we find ourselves in is that the Royal Court has just accepted and adopted the provisions from the Court of Appeal law from 1961. So all those provisions there, you can see little 1, 2 and 3 come from section 25 of the Court of Appeal Guernsey law, but will be applied to appeals from the magistrates to the Royal Court, and also including the proviso in there that even if there is a meritorious ground of appeal, if there's been in fact no miscarriage of justice, then the appeal will be dismissed. So all of that's been imported into appeals from the magistrates' court. As I say in 1016, strictly speaking, of course, they're only relevant to appeals against conviction. So query what the test would be on a prosecution appeal against an acquittal. Probably to do with, I don't know, error of law. I can't see it being much else beyond that. And of course, it's as far as sentence is concerned, it says court can interfere, substitute the sentence that it thinks it ought to have been passed, if indeed it does think they're a different sentence. And that could mean perhaps going from custodial to a non-custodial, or it could mean maybe fewer hours of community service, or maybe fewer months of imprisonment, that type of thing. Yeah.
I mean, with the it's different for me. Really careful. There's some Guernsey cases on that.
Yes. I think we did touch on this before, didn't we? I can't think of exactly the subject that we were looking at when we did touch on that, but yes, the test in the Criminal Appeal Act 1968 is simply, is the conviction safe or unsafe? That's not the position here. This is going back to 1907. Okay, so on the hearing of an appeal against conviction, the Royal Court is usually constituted just by the bailiff alone. No need for jurats unless there are matters of fact for them to consider. Yeah, it's difficult to think what that might be in particular, unless maybe one is looking for some fresh evidence, perhaps. You've got this Holland case there. Judge of the Royal Court was of the firm view where an appeal was based either on sufficiency or presumably insufficiency of the evidence or a wrong decision, a question of law. These would be matters for the bailiff alone to determine, so no need for jurats there. But there was this third position, the miscarriage of justice. On the facts of that case, there were no genuine issues of fact, and thus it was fine for the bailiff to sit alone there. But I suppose that does kind of flag up the idea that there might, if there were going to be genuine issues of fact, that the court needed to determine to resolve the appeal satisfactorily, then they could have jurats. Obviously, with an appeal against sentence, you would normally expect the jurats to be present for that. Yes, all right, 1019, where a trial judge has had the opportunity to observe witnesses, any findings of fact that that judge has made will only be overturned on appeal if they are perverse or no reasonable tribunal could have made them. And let me see. You've got this case of Burney there. So let's just skip it over a few. We'll get there, I think. Yeah, okay. Yeah, so paragraph 7 of the judgment in Burney, I think that first bit says exactly what we have just looked at in the study guide, but the court then went on, if any further elucidation is needed, observations of Lord Justice Lewison in another English case, Farge and Chabari UK in 2014, highly apposite. So expertise of a trial judge is in determining what facts are relevant to the legal issues to be decided, and indeed what those facts are when they're contested. Second point, the trial is not a dress rehearsal, the first and last night of the show. Yes. Obviously a theatrical bent, Lord Justice Lewison. Thirdly, duplication of the trial judge's role on appeal is a disproportionate use of limited resources in the appellate court, seldom leading to a different outcome in individual cases. In other words, don't ask us to give you a second bite of the cherry. Fourth, in making his decisions, the trial judge will have regard to the whole of the sea of evidence presented to him, whereas an appellate court will only be island hopping. Probably thinking about booking his holiday as well at this point. Then. The atmosphere of the courtroom cannot in any event be recreated by reference to documents, including transcripts. 6, thus, even if it were possible to duplicate the role of the trial judge, we can't do it. Yeah. So, factually, if you're unhappy with the way the facts have been determined, basically you're just going to have to lump it. Yeah, basically. All right. Okay. Now, something else that did crop up in Burney was as a different basis for appeal, as you can see at 10.20, the way that the case was handled by the defendant's advocate. Yeah. So the Court of Appeal in Burney referred back to an earlier case, Collins, from 1989. As you can see there, saying that conduct of counsel is capable in some instances of giving rise to a ground for setting aside a conviction, but such cases are rare. Principle that emerged from the authorities, flagrantly incompetent advocacy. That's again a test that the Court of Appeal in England and Wales would recognise. Flagrantly incompetent advocacy could lead to such injustice the court would feel bound to intervene. However, counsel's decision not to call evidence was a reasonable and sensible one. Yeah? And back in Burney itself, you can see the Royal Court said there, subsequent decisions concentrate on whether such manifest incompetence was displayed by the defence advocate as to deprive the defendant of a fair trial. So that's really the test that we're left with at the moment, fair trial. Yeah? In Burney itself, I think our friend from yesterday, Mark Dunster, was the defence advocate that was slagged off by Mr. Burney. So it's a shame he's not here to explain himself. But I think to be fair, the Court of Appeal basically made it very clear they'd done a very thorough, if you like, examination of behind the scenes, kind of back office stuff that gone on, communications and correspondence between Bernie and his advocate, and had nothing but admiration for the way that Advocate Dunster had dealt with this particular case. And I think, well, you kind of get a flavour of if you like, how easy a client Mr. Bernie was by the fact that in the judgment there, they make the point that Advocate Dunster had only accepted the instructions because he was Petonier at the time, and that nobody else on the island was prepared, apparently, to represent Mr. Bernie. So I think the court was very sympathetic to the position that Mark found himself in, and found that he'd handled it very professionally. So there we are. Any criticism was completely unjustified. Right. Powers of the Royal Court. What can it do? Well, unsurprisingly, it can do everything that appeal courts can normally do on appeal. So it can uphold the original decision, overturn it, or vary it. It can send a matter back to the Magistrates' Court with its opinion as to what the Magistrates' Court ought to do, or make any such order as appears just, exercising the power that the Magistrates' Court had available to it. Okay.
I don't know. I mean, mostly they reject them because that's the nature of the proof.
End of story. The carer.
Yeah.
Yes. Oh, we looked at that extensively yesterday. Well, they've got the jurisdiction to do it, so why delay matters? Yeah. Okay, so 1022 then. On a defendant's appeal, the Royal Court may vary the sentence, impose a sentence either more or less severe than that which was imposed in the Magistrates' Court, as long as it's within the jurisdiction of the Magistrates' Court. And sorry, go on. Yeah, well, Clark, I've got two examples in the footnote there. Yes, Clark from 2005 then. And I don't think they did increase the sentence, but you can see paragraph 12 there, the court further considers the magistrate was right in ordering a suspended sentence of 3 months to be served on a consecutive basis. 13, court would remind defendants that this court, when hearing an appeal against sentence from the Magistrates' Court, has a power to increase, exactly that point. Those who are minded to appeal should take note of this. The court gave serious consideration to increasing the sentence of 5 months for the assault. Yeah? And they also made the point about costs there. Court, in the case of an unsuccessful appeal, may well order the appellant should pay for the cost of preparation of a transcript and up to £75 to cover the law officer's expenses. You and other defendants should also bear this in mind. So a very stern warning there. Yeah, this is an interesting, well, I say interesting one. Depends how much of an anorak you are. So this is, I'm going to let you guys tell me how this should be pronounced. Ogier? Ogier, all right, okay. From 2012. Mr. Appellant Ogier appeared unrepresented for reasons that will become immediately obvious. He had been sentenced to 2 6-month prison terms to run concurrently. He then appealed on the ground that they were manifestly excessive, and what he should have had was 2 3-month sentences running consecutively, which the more numerate amongst you will realise basically is the same thing. Yeah, so I suspect this is why he was unrepresented. Who would put themselves in that position? So the court said, yes, I should add, the court's previously said that frivolous appeals should not be made, and reminds appellants the sentence can be increased if they think it's appropriate. This is a case, Mr. Ogier, where the outcome is not that much different from what it could have been because you did not query the totality of the sentence. So, to a certain extent, the court is troubled that such an appeal has been brought. But that was it. That was as far as they went on that particular occasion.
Really? Never had a conviction for 3 months.
I'm not aware. I mean, I can see what you're saying. I'm not aware of any situation where that would be pertinent. Or maybe where, yeah, maybe a situation where it would be, you know, like he'd be preempted from obtaining employment, a particular employment, if he'd received a 6-month sentence. Yeah, yeah, yeah. Yeah, I don't know. He certainly didn't. He didn't raise it with the court anyway.
No, because it's below the threshold.
Well,
no, you still get your third. But I don't know if then he's
well, it might make a difference, but the honest answer is nobody knows because he didn't advance any. He just said it was manifestly excessive.
That's the only thing that was
Coming back to your point about they never send it back, there is actually an example, yes, which will be coming up hopefully any moment now. It's a fairly old one, 1994. Yes, it's quite a nice one. Yeah, failing to provide a specimen of breath, said she had a reasonable excuse for such failure. She was too drunk to understand the procedure. The acting magistrate, it had to be, didn't it? The acting magistrate accepted that argument and acquitted her. Law officers appealed. So this was an appeal against an acquittal by the law officers. The bailiff held this factual situation was not capable of amounting to a reasonable excuse on the part of the defendant. The court then quoted from Lord Justice Wolfe, as he then was, in a very early case of DPP and Beach. It would, in my view, defeat the object of the legislation, which is intended for the protection of the public, to hold the fact that the defendant was too drunk to understand what was said to him, could provide him the reasonable excuse. Otherwise, we'd all be at it, wouldn't we? Wouldn't we? I don't know, or possibly not.
I suspect this is part of the run of cases where Nick Garland's mainly went through the drug legislation paragraph by paragraph and systematically destroyed it. The registration, from the registration but there's a whole run of these cases. That's interesting.
Well, my suspicion is the reason why that got referred back would be, or remitted back to the magistrates, was basically to kind of, you know, learn this lesson. Don't do this again, type of thing. Yes, yes. Yes, well, and possibly to R as well. Yes, all right. Okay. Right. Yes, okay. So, as you can see, at 10:23, it is possible to have evidence presented to the Royal Court on an appeal. As it says there, if it seems there's a material error in the transcript, but nobody can agree as to what actually was said at the time, or if there's no transcript available and the court thinks it's desirable to hear someone that testified at the original hearing, or fresh evidence, material new evidence that was not available at the original hearing, now available in the interest of justice to hear it, which is a very abbreviated version of the test that the Court of Appeal would apply in that situation. In terms of material new evidence, we might kind of say that wraps up inside itself issues around the credibility of the source of that information and issues around admissibility of it as well, and relevance. So is it admissible? Is it relevant? Is it credible? Okay. So frivolous or vexatious appeals can be dismissed at any stage. Yes, Royal Court can use its inherent jurisdiction to sit in private on appeals from Juvenile Court, which is the case of X, which we looked at this morning. Appeals, as is often the case, can be abandoned. So as you can see, written notice not later than 2 clear days before the date that's been set for the hearing of the appeal. It will then be dismissed. court has the power to give leave, which it would normally be doing if you leave it later than 2 clear days before the date set for the hearing itself. As you can see also, if security was taken in connection with the appeal, then that may be released when the appeal is abandoned. So examples, I don't think I need to go through that, but you've got one example there of Burtonshaw. The big complaint that Ms. Burtonshaw made was that she wasn't reminded before she went into the witness, but she was unrepresented, wasn't reminded, excuse me, by the court before she went into the witness box, that it was entirely her free choice as to whether she testified or not. She'd been told about it at the start of the trial, but she wasn't reminded before she went into the witness box, and apparently dug a big hole for herself. So yeah, she said that was a procedural irregularity, and the Royal Court dismissed the appeal. There is no such thing as a perfect trial, but this was a fair one. Mrs. Burtonshaw is plainly a loquacious woman. The transcript indicates that she was anxious, if not bursting, to give her side of the case. So whilst it might have been good practice to have reminded her that she didn't have to testify, frankly, it wouldn't have made any difference because she would have knocked you out of the way to get into the witness box. Yes, 10.30 McGrath. So when the judge of the Magistrates' Court gave his reasoned decision finding Mr. McGrath guilty of whatever offence it was, when he gave his reasons, he didn't refer to McGrath's good character, okay, and therefore concluded that the judge, McGrath said, the judge hadn't directed himself properly. The Royal Court drew a distinction between when the bailiff is summing a case up to the jurats, when a full character direction should be given where it's appropriate, and if it wasn't given, that would probably wipe out a conviction, but said that that's different from the process of giving a verdict in the summary trial. Judge then stated the decision must contain reasons sufficiently adequate to demonstrate the essential issues have been dealt with and resolved, and quoted from Lord Justice Tuckey in an English case, Brent Justices, saying the essence of the exercise in a criminal case such as this is to inform the defendant why he has been found guilty, can usually be done in a few simple sentences. Row we've already looked at, so that's good. Right. Right, so yes, further appeal. So if you don't like what the magistrates did and you've appealed to the Royal Court, you don't like what the Royal Court's done either, can you take it further? Apparently, yes, you can. When the Royal Court dismisses an appeal from the Magistrates' Court, whether it's a D or a P, then they may appeal again, this time to the Court of Appeal. And I'm assuming, Catherine, please fill me in on this, but if the defendant appeals successfully, I'm assuming the prosecution can then appeal to the Court of Appeal, or vice versa.
I don't think the only right that the prosecution has is to appeal to the magistrates.
So you don't think they can take it to the Court of Appeal?
No, I don't.
Okay. So basically, all right, okay, yeah. Right.
I mean, they certainly can't have an issue, as it were, whether they can do it on one that started in the Magistrates' Court is a moot point, but I don't think so.
Okay, thank you. So, as we can see, leave from the Court of Appeal is required. And as it says there, it seems to be accepted in practice that the further appeal may only, well, you see, may be against either conviction or acquittal, but not an appeal against sentence. Yeah. No, all right. Yeah, all right. Well, that's past the adjuncts test, but who knows? Who knows? So the appeal must be either on the ground of pure law, or get a certificate from the bailiff if there is sufficient grounds of appeal to justify it being heard by the Court of Appeal. Application for leave, as is usual, goes to a single judge. If the single judge turns it down, you may renew the application to the Court of Appeal. Note that the appeal to the Court of Appeal is against the original decision from the Magistrates' Court. It's not against the determination on the appeal by the Royal Court. And you can see there reference to Snowden. position is different where the appellant originally pleaded guilty and wishes to appeal his conviction. And yeah, you've got some notes in there about that. I think the interesting point about that is that with that one, he was, as it says, he was before the Court of Alderney, and he was basically, he pleaded guilty, he wished to change that, but it wasn't allowed. Pleaded not guilty and then wished to change that. And eventually that's what happened after a bit of toing and froing. Plea of guilty was entered, and he was sentenced to a fine and a suspended prison sentence. Subsequently, he applied to the court for leave to appeal, which he had to get because he pleaded guilty eventually in Alderney, on the basis that, as I say, he was under the influence there. That application for leave was heard by the deputy bailiff, and the deputy bailiff refused to grant leave, saying it wasn't an exceptional case, which it had to be because he pleaded guilty. Yeah. He then applied to the Court of Appeal for leave to appeal, and basically it turned out that that was an end to it. There was no basis to give leave to appeal because the appeal hadn't been dismissed. Well, it was an application for leave to appeal that had failed. So that's what we call a nice point. A nice point of distinction. Also interesting, it's an interesting read. As you can see, the Court of Appeal said that Mr. Snowden's wife, who had argued his case in the Court of Appeal, had done a thoroughly good job in presenting the arguments, unsuccessfully, as it turned out. Wow. But they are one, surely they are one and the same, Mr. and Mrs. Snowden.
Well, there's that.
Yeah, well, there you go. Costs. Costs, no, I don't think there's anything I particularly want to say about costs. Oh, except for, yes, the reference at footnote 849. And again, this is as far as I can take this. I haven't found any update to this, but obviously there are provisions here. You can see them in 10.37 for the Royal Court to order cost, and we saw that reference to the case of Clark, where the Royal Court made the point to Mr. Clark that costs could be ordered against an unsuccessful appellant. So that's all well and good, but you can see this reference in Ratcliffe against law officers, which is of no interest to anybody apart from this. Paragraph 8 of that judgment, the Court of Appeal noted on a prosecution application for a costs order, it turns out there is absolutely no power to award the costs that were being sought. So there you are. I can't take it any further, but the kind of dialogue between the court and the Crown Advocate there is reported, and the reported response from the Crown Advocate was the provision is within the law, but it requires something else that has not yet been put in place, which I assume is to actually bring it into effect. So I'm sorry to have wasted your time. There you go. We then have a notice, the notice for appealing from the Magistrates Court, and there's not a lot, I think, that I want to say about that. Obviously, it's handy to have a look at it and just think about where some of these provisions kind of fit within there. And you can see a reference about halfway down the page on page 189. It says there, my grounds of appeal are set out grounds in full, and in brackets include where section 2(1)d applies. And that's the whole point about not being able to appeal against sentence or conviction when you've got one of those very light or low sentences. Right? Anyway, we will leave that there. Appeals from the Royal Court, sitting as the full court, up to the Court of Appeal. So section 24 of the 1961 law, person is being convicted on indictment or on apparently the rare occasions where one is summarily convicted in the Royal Court, may appeal to the Court of Appeal either against his conviction by right, if it's a pure question of law, or with leave of the court or a certificate from the trial judge that it's fit for appeal against his conviction on any question of fact or mixed law and fact or anything else that appears sufficient to be a ground of appeal. And again, he can appeal with leave against sentence unless it was a sentence fixed by law. So procedure, notice to be given to the registrar within 10 days of conviction. As it says, a short period of time for reasons of legal certainty, which is understandable, but the Court of Appeal has the power to extend that. Fernandez, an application for leave was made 15 months after the relevant order and was refused. That is the deportation thing, yes. So Mr. Fernandez was sentenced to some jail time, and subsequently, and also the court made a recommendation for deportation, and he, yes, applied for leave to appeal out of time. So it's over 15 months after the date of his sentence, and obviously 15 months is quite a lot later than 10 days. So he was considerably out of time there. And you can see in paragraph 14, this has been explained, because obviously the court, what the hell's going on here? So the explanation was the applicant, Fernandez, had all along wished to appeal against the recommendation for deportation, but had been unable to obtain legal representation and hadn't understood the process. Right? We find this difficult to accept an adequate explanation, and they go on to say, well, he was represented at the sentencing hearing, and it's part of the representation at the sentencing hearing that your advocate gives you advice in the immediate aftermath, including whether there's any grounds for appealing against any part of the sentence. Yeah. What else do we need to think about there? Reference to legal certainty, we've already thought about that. Final and certain conclusion of criminal proceedings is a matter which is in the public interest, and it's also in the interest of the parties to the proceedings, such as victims. I didn't know they were parties to the proceedings, but apparently they are, and the Crown, and it's in the interest of the courts as well. It would be against all of those interests to allow applicants who have not previously evinced an intention to appeal to be permitted to do so substantially after the time limit which is provided by statute, unless the circumstances are most compelling. We have not found such circumstances to exist in this case. Furthermore, an interesting addendum, even in a situation where the delay can be excused, the court should consider whether the appeal has any prospects of success before it gives leave to appeal out of time. And it says here, paragraph 19, we can't find any justification for the appeal. It's not a compelling case.
I think what actually happened was that he didn't realise that the recommendation for deportation had been made, and that's why he instructed somebody sometime later to tackle it. It happened. There have been more challenges lately in relation to the recommendations to the court, and I think that's what happened.
Okay.
The last paragraph demonstrates that business that if they think they might grant the appeal, then they're excusing most of them that's gone a long way. And if they think it's rubbish, then they won't be doing it. We talked about the previous weekend, they tend to do their leave application along with substantive appeal.
Okay. 1042, 1043, basically kind of housekeeping. Matters in terms of transcript, preparation of court bundle. Not really anything significant to add to what you've got there. You can see at 1044 on an application for leave to appeal against sentence, particular documents being required, obviously to enable the Court of Appeal to get an understanding of what was going through the sentences or sentencers, plural, minds when they came up with the relevant sentence. Does the appellant have to be there? As you can see, he's entitled to attend the hearing, even if he's in custody, so he'll have to be brought up from prison, unless the appeal is purely a question of law. However, on preliminary hearings, maybe like an application for bail, that type of thing, or just an application for leave to appeal, he's not entitled to attend, but the court may allow him to attend. Yeah.
Not unusual for people to come.
Yeah. Well, it's their lives. So
exactly.
Yeah.
I won't be very happy.
All right, bail. As you can see then, pending determination of the appeal, the appellant may be released to bail by the Court of Appeal, and fairly commonsensibly, any time that he is on bail won't count towards serving any sentence. that has been and continues to be imposed on him after the determination of his appeal. Legal aid. Yeah.
The guide, there's a page of questions that very short questions about means, and usually that sheet is part of the notice of appeal. So what we do is the notice of appeal goes in with the grounds and the questions, and the court itself deals with the application for legal aid. So the one I watched last week before, I've been granted 2 hours preliminary legal aid to assess the merits of the appeal by the court. And it doesn't get taxed, it's not part of the legal aid service. I'm pretty sure that the Magistrates Court to Royal Court is just ordinary. There is a legal aid service legal aid, but this one is not. This is definitely the court itself. But it doesn't do that assigning of an advocate because people tend to, they either need the offence, stick with the advocate who represents them, they go somewhere else. Where's this one? I think
It's towards the it's pages 199, 201.
Yeah. Okay. And so there's a sheet. I don't know which.
No, I might not have included the legal aid
Okay.
part of that.
Well, there's another page basically.
Yeah, form 3, I think.
Which is in
Oh, is it maybe page 200 where it asks about a legal aid?
You know, it's there. It's
Oh yeah,
it's
question
page
2.
200.
Question 2, yeah.
It's page 200. So it's not terribly complicated. You just say, I'm in prison now, so I'm not earning anything. So I need legal aid. Which is a much less onerous business than getting it through the Guernsey Legal Aid Service. That's how it works in practice.
Right, okay. Grounds of appeal. So as you can see there, following conviction and sentence, if in the opinion of the advocate, which gets us back to that whole point about maybe Mr. Fernandez, and what's covered by legal aid, so advice. So if you're advised that there are potential grounds of appeal there, client instructs the advocate to do so, then the advocate is to draft formal grounds of appeal, which is, it says there, reference to Practice Direction 2, 2015, should be substantial and particularised and not a mere formula. So, for example, it's no good complaining about sentences, simply saying it's manifestly excessive, but explain your
What I
reason.
say is the long start, whatever it is that's gone wrong, you've got to set it out.
Right, 1050, verdict of guilty may only be set aside on evidential grounds where the verdict is obviously and palpably wrong. That was approved in Hasty from 2015, and you've got quite a lot of detail there, which was, as it says, subsequently dealt with by the Court of Appeal in Jones from 2016. Sticking with Hasty, the court said there, ground of appeal that there's no evidence will not succeed where there is some evidence, surprisingly. The question of its reliability, assuming there is some evidence, reliability, credibility and sufficiency are all obviously matters of fact for the jurats to determine. It's not sufficient to allege that the verdict was against the weight of the evidence. A verdict will only be set aside in those rare cases where the verdict can be shown to be obviously wrong. No part of the powers of the Court of Appeal to review the totality of the evidence, sift through points of alleged weakness and attempt to make a judgment on an appellant's guilt or innocence. There you go. Right. Okay. Moving on. So, as you can see, 1051, human rights rears its head again. Various cases, you've got a couple of examples there, Ascalese and Elkington, although as it says, both of these are in fact decisions from the Royal Court on appeal from the magistrates rather than decisions of the Court of Appeal. But they're quite interesting cases. I'm not going to go through them. They're quite legally complicated cases. but I thought I'd just jog on a little bit. I did say Gemma I'd included a slide which I thought would appeal to her. So we'll just have a quick look at this. So this is Ascalesi from 2015. This was a sexual offence case. So these were the 4 questions that the appeal court had to consider. As you can see, it's indecent assault, but there's a lot of concern here. I think the complainant was 13, and there's a time limit for bringing an allegation of unlawful sexual intercourse. Yeah, well, which we'll see in a moment. So there's a time limit for bringing that, and they were outside the time limit, so they charged it as indecent assault instead, which didn't have, I don't think it had a time limit at all. It only had a much longer time limit, so they were still in time for indecent assault. So that's, but there was a lot of query about what were the elements of the offence. So as you can see there, point 3, does the offence, however it's constituted, whatever decision we make on what the elements of the offence are, does it offend against the appellant's rights under the ECHR, and also how, bless you, and if it isn't convention compatible, do we need to make a declaration of incompatibility? So, principal issue in this appeal, therefore, is to consider whether the elements of the offence of indecent assault, which is a customary or common law offence, are sufficiently clear and precise, particularly in relation to the mental element to be proved to enable the appellant's conviction for the offence to stand. So, a bit of legal analysis to be done there. And then, here you go. Article 1 of the 1907 law made it a felony to have unlawful carnal knowledge of a girl below the age of 13. Article 2 created a number of other offences termed délit, which carried a maximum term of imprisonment of 2 years. Amongst these, at alinea 7, was, and there we go, this was made subject, however, to a proviso at the end of the article, etc., etc. Yeah. The court then reverts to English. This proviso is, of course, the same proviso as appeared in Section 5 of the 1885 Act, relating to unlawful carnal knowledge or an attempt. Whether or not something was lost in translation remains a mystery. So there you go. I think you should quote that. Yes. No, I thought you'd like that. Oh dear. Yes. Yes. All right. I think this next bit is another passage from Hastie, where they basically come to a conclusion about that. Nothing contrary to the convention rights for Mr. Hastie in Section 2 of the 1956 law, and I think that's the Sexual Offences Act of I suppose the Guernsey equivalent to the Sexual Offences Act of 1956. Legislature must be afforded a margin of appreciation how to give effect to what it regards as necessary or desirable protection to girls below the age of consent. Has done that by creating a specific defence for men who are within a defined age range, and in doing so, it has excluded the possibility of a similar defence being advanced on behalf of older men. Yeah? And in case you wonder what the hell this is rambling on about, I've included the next bit there. As a matter of law, the choice of the legislature here to use a man's 24th birthday as the point at which he loses the opportunity to advance the reasonable belief defence as to the girl's age does not constitute a convention breach at all. Okay? So there. Yes, can I just see your passport, please? So there you go. Right, okay. Well, if it isn't Hastie, I don't know where it's come from then, but we'll move on.
It's just it talks about the conclusion of magistrates.
Elkington.
Yeah.
Oh, sorry. Yes, it's not Hastie. You're right. It's Ascalesi. Yeah. And just one other, the Elkington one. I'm not going to really say very much about that, but yeah, convicted of TV licensing offence. sought to use the ECHR. But anyway, there we are. So just a couple of examples there. All right, so Appeals against sentence. The Court of Appeal will allow the appeal if it's the sentence was beyond the court's powers, so in excess of its jurisdiction, wrongly in principle, or manifestly excessive. They are very standard terms for an appeal against sentence. Yeah, so again, I've got the case of Wright there, as it says, as an example of this. It's a peculiar, somewhat disturbing case. So manifestly excessive sentence, Mr. Wright from 2011, convicted in the Royal Court, 2 counts of indecently assaulting a child, 11 counts of viewing indecent images, 2 counts of downloading images onto a computer. Okay? Sentence was imprisonment for a total of 4 years, extended sentence of 5 years, and also the court ordered the forfeiture and destruction of 2 computers that were involved in all of this. And he appealed against sentence relating to the forfeiture order on the computers. Okay, he said that he had personal material stored on his computer, including family photographs, a bit dodgy, genealogical information, and music. He claimed to have, I think, literally thousands of CDs that he uploaded onto the hard drive of the computer, which he reckoned was something like £15,000, something like that. And the court said, well, they'd have to all be worth between, I think it was like £25 and £35, which seems quite expensive for a CD. But anyway, so yeah, about £15,000 worth of music, and he wanted it to be copied off of the hard drive and restored to him before he said, you can destroy the computers and the hard drives, but I want my personal stuff, including my music, off of there first. And the Royal Court turned that down. Yes, I don't think I actually put in anything else to kind of justify a rationale for that. But yeah, they said it was going to be, I think the law officer's objection was not that it was technically impossible to pull that information off of the hard drive before destruction, but that it would be a very time-consuming exercise, expensive, difficult for the people doing it to know necessarily what was an innocent family photograph compared to some of the other things that were stored on there. And also the court was concerned about the intellectual property rights over the music that had been uploaded onto the hard drive as well, and didn't want to either render itself or whoever it ordered to extract the music from the hard drive and then pass it on to Mr. Wright to be the subject of any future IP claim by iTunes or somebody else. I don't know. So they turned that down, and the computers were taken away and presumably attacked with the sledgehammer. So there you go. Right, powers of the single judge. Pretty much the single judge can do everything except actually, allow an appeal. I think is the short answer to that. So we need to detain ourselves too much with that. Powers of the Court of Appeal. So as it says, an appeal against conviction will be allowed where the verdict is unreasonable, cannot be supported, judgment should be set aside on grounds of wrong decision of law, or miscarriage of justice subject to that proviso. So these are all things that we've already looked at. Don't need to go on any further with that. Appeal against sentence. If the Court of Appeal considers a different sentence should have been passed, it can quash that sentence, pass any other sentence that it considers ought to have been passed, again, whether more or less severe than the original sentence. And that, again, is a difference from the English Court of Appeal, which can vary the sentence, but cannot pass a sentence that overall is more severe than the original sentence passed in what would be the Crown Court in England and Wales. All right, 1055 takes us through that kind of legal history lesson, going back to 1907, which we have previously thought about. Oh dear, yes, all right. Gordon Dawes was very keen to have this explained as clearly as I hope it is explained now. He's certainly given his seal of approval to the current text. So just to make the point that it is a test, legal test that goes back to the early part of the 20th century. I think he is concerned about the whether it's an appropriate test, whether it's ever going to be revised or revisited at all. And he was very, well, it is the test. But anyway, so he was very keen that there was this reference to this article by Advocate Kelleher, because there's a very similar situation in Jersey, and you can see, the argument was made in the, I think the Jersey and Guernsey Law Review from 2011, that the current test is unsatisfactory. So he was very keen that I bring that to your attention, which I have now done.
Well,
Catherine?
it is unsatisfactory. And it's been said in one of the cases, it's likely that might be one of the others. There's the one about the canvas at the helmsman, and it's that one, where it is perfectly possible that on the same facts and appeal would be allowed in England, but not allowed in Guernsey. And the practical consequence of that is that you have to manage your client's expectations, because they will continue to use the words unsafe because that's what they use in the English newspaper. And you also need to be very careful about looking at appeal decisions in England, because the test is different. And so the point that you need to go forward is that the test is different, right or wrongly. I'm almost certainly I am in full agreement that it's wrong. It can't be right that in certain circumstances the conviction is left in place because of the test. And I think that's what happened in the Helston case. It might be that one where the Court of Appeal actually recorded that they had disquiet about the conviction, but they felt constrained by the test.
Yeah, but as you say, I mean, the test is the test.
Yeah.
So,
I think it's more of a practical problem than where I've been looking for decisions.
Yeah. Okay. Thank you. All right. So under the heading, somewhat mysterious heading of special cases, 1058, 1059, the Court of Appeal can consider that the appellant was not properly convicted on some part of the indictment and therefore presumably allow the appeal to that extent, but was properly convicted on another part, then the court may uphold the original sentence passed at trial or substitute a new and different sentence, such as it thinks proper, based on that part of the indictment on which he was properly convicted. So it can uphold the sentence, or it can vary the sentence there effectively. Likewise, 1059, essentially substituting conviction for a different offence, having allowed the appeal against the original conviction. So convicted of an offence, satisfied that he could have been found guilty of another offence, and the trial court must have been satisfied of the facts that would prove him guilty of that other offence, then instead of allowing the appeal, the court can substitute the verdict of guilty of the other offence and then pass an appropriate sentence for that new one. But this time they are limited to a sentence that is no more severe than the original one for the conviction they just set aside.
If your powers aren't increased then in terms of what you can impose on a sentence, why would you substitute that?
Well, I guess it'd just be rectitude of decision, basically, that you consider that the material isn't there to justify conviction for offence A, but it had to have been there to justify the conviction for offence B, then just to make sure that, you know, all the I's have been dotted and the T's have been crossed. Yeah. I mean, the likelihood is that they're going to go for a lower sentence anyway, because it's probably going to be a lesser offence that they're substituting. Yeah, it'll probably be a lighter sentence. So, but it's just they can't go above that the original ceiling. That's the point. I mean, it's always going to have to be. I think what the law refers to as an included offence. So it would be an offence that is contained within it. Yeah, either explicitly or implicitly. Yeah. So I think from that point of view, yeah. So for example, I don't know what your law is on burglary over here, but in England and Wales, burglary would be something like having entered the building as a trespasser stole. That would be a classic example of Section 91B Theft Act burglary. Having entered as a trespasser stole. It might be that the Court of Appeal decides there isn't sufficient evidence of trespass, but there's stone cold evidence of theft. Yeah. So they'll quash the burglary conviction, but substitute the conviction for theft of the same property. But because theft is generally seen as a less serious offence than burglary, Residential burglary in England and Wales, maximum 14 years. Theft of any amount of property, maximum is 7 years. So on a very crude measure, it's half as serious as burglary is. So that's typically how it works. Is this other offence included within the definition of the offence that we're striking down the conviction for? And it might be expressly, you can just cross out words and you're left with another allegation, or it might be implicitly. Right, fresh evidence. We've already kind of touched on that, so I think we can take this fairly shortly. But you can see there under the 1961 law, the Court of Appeal can receive fresh evidence if it thinks it's necessary or expedient in the interest of justice. And you have those 4 points that we've already kind of flagged up in at 1061. Must be evidence that wasn't available at the original trial. It has to be relevant, it has to be credible, and it must be material there. Court must consider that if it had been called at trial, there might have been a reasonable doubt as to the defendant's guilt. Where the court is satisfied that the first principle, that it wasn't available at the original trial, is not established, then it's going to kiss goodbye to anything else. So the basic question is, could you have called it? And this is going to trip up defence lawyers who had, sometimes it works with like expert evidence. You have an expert, you're thinking, do we want to call that expert or not? Maybe we'll leave it and just, if we get convicted, we'll maybe think about calling them on the appeal. Then you appeal, say, well, fresh evidence, let's see the expert report then, shall we? And the Court of Appeal says, well, when did you have this evidence? You had it at the start of the original trial, didn't you? Yes, we did. You made a tactical decision not to call it. Well, yes, we did. So shut the door on your way out then. Yeah. So you can't make these tactical decisions or judgments and then expect the Court of Appeal to bail you out when it all goes horribly wrong. Presslander, you've got a little quote there. I think it pretty much speaks for itself. Germain, I don't think there's anything that I particularly want to add to that. You can see kind of like in that paragraph from the Germain judgment that all of the reasons why the Court of Appeal is going to be fairly disciplined and stern in terms of not allowing fresh evidence appeals. You can see ex post facto examinations of concluded trials would bring a host of problems in their wake. And Germain is a classic example of that, where I think her name is Natasha, abbreviated to Tasha possibly in the report of the decision. But anyway, she had allegedly headbutted Helen, somebody or the other, and there was an eyewitness to this called Lisa, I think. And Lisa she made a statement to the police about how she'd actually seen Tasha headbutting Helen. She didn't turn up to the trial. Helen testified. Tasha was convicted of assaulting her, but Lisa didn't turn up. She had been warned by the police. She'd been served with a notice, which she had signed to say that she was on notice that the trial was starting and when it was starting. She didn't turn up. Nobody bothered to get a summons to call her. Defendant, when she didn't turn up and the trial went ahead, the defendant didn't bother to call her. After Germain was convicted, she then got a second witness statement from Lisa to say, basically, I was coerced into making that statement by Helen, the complainant, and I know you didn't hit her. And the two of you had a verbal spat, and then you just kind of walked off in your separate directions. And basically, I think the court just concluded that Lisa was a completely hopeless source of information who was fatally compromised by these two utterly contradictory witness statements. But insofar as in her second statement, she justified or explained the first one by saying that Helen had intimidated her into making that first statement to get back at Tasha. The court took the view that there was plenty of other material, like, for example, a special measures application that had been made, I think, to screen the witness box off, had Lisa turned up to testify, that actually Lisa hadn't been intimidated by the complainant, Helen, at all. She was, in fact, she was being intimidated by anybody. It was Tasha, the accused, who was putting herself about. Anyway, yeah, it's just an interesting little case in terms of, if you like, the everyday issues of getting people to turn up to court, not knowing actually what they're going to say or whether they're going to recant it, have a withdrawal statement, throw themselves over the fence to the other side, which is effectively what happened with Lisa, allegedly. Yeah. So, All right. 1064, the Court of Appeal can appoint a special commissioner to do the legwork, if indeed legwork is involved. So you can see lengthy examination of documents or accounts, scientific or local investigation. Then rather than having a day out from the court themselves, they can get a special commissioner to do that and then report back to them. Appeal can be abandoned on the usual points there, as it says, if it is abandoned, there may be adverse consequences, and then orders for disposal of property. So it will be suspended if there is an order for disposing of property, like say with Mr. Wright's computers, for example. That will be suspended for 10 days in order to determine whether there be an appeal against conviction or not. And if notice of appeal is given, or leave to appeal is given within the 10 days, or I'm guessing applied for within the 10 days, then the disposal order is suspended until the appeal is eventually resolved. What else do we need to think about? Nothing. I think the forms can just be left to their own devices. Court of Appeal to the Privy Council. We did look at this a little bit in the previous weekend when we looked at Chapter 1 and the way the courts are set up and structured. So I don't think there's anything particularly new to draw attention to here. There's some points arising out of various rules from the Judicial Committee Appellate Jurisdiction Rules of 2009, but I think everything that I would want to draw attention to is there. Some very technical stuff which I don't think you'd ever need to worry about unless you were actually prosecuting an application to the Judicial Committee. Yeah, there is an example, it's not a very helpful one, but an example of a recent Guernsey case, criminal case, that got to the Judicial Committee, but yeah, they weren't successful with their application for leave, is Doyle against the law officers. I haven't found a report of the judgment in Doyle from the Privy Council because they turned down the application for leave. I strongly suspect there is nothing really for me to find there. But I sincerely believe that this is the culmination of the case that appears in footnote 908, which was Doyle against the law officers from 2015, which was essentially a money laundering case, where I think Mrs. Doyle had set up an unlicensed or unregistered business and were then basically laundering money for one particular named individual. Yeah, so they basically any kind of money laundering offence you could think of, they got done for. I think including tipping off. But yeah, so anything you can think of, they were guilty of it. They just kind of laid down a welcome mat for that particular individual. And last and by all means least, royal prerogative of mercy. Insofar as it exists at all, you can, I guess, assume it from the fact of Section 42 of the 1961 law saying nothing in this part of this law shall affect the prerogative of mercy. And Section 42 says that the Secretary of State may, if he thinks fit, refer to the Court of Appeal, conviction, indictment, summary conviction, or a sentence other than a sentence of death. And then the court would proceed as it would in the case of an appeal against conviction, or presumably an appeal against sentence if it's sentence other than the sentence of death. Yes, it's been suggested by Dawes in Laws of Guernsey that this power of the Secretary of State to refer with any views where exceptional circumstances require its use may be significant fresh evidence had come to light, or conviction of a co-accused had been quashed, which presumably casts some significant and substantial doubt on the validity of the particular individual's subsisting conviction.
the other circumstance might be where the current Court of Appeal test
Yes.
leads to a conviction remaining on the books that is very much questioned by the Court of Appeal.
Mhm,
They would just say, not just that they are disquieted by it, but that, you know, they felt very strongly that in another jurisdiction it would go. That might be a reason to.
Yeah, yeah.
I have to say that actively.
Who's the Secretary of State from State?
Yeah, well, good question. No idea.
It's always worth going back to books. You know, we dip in and out of it. It's sort of, you know, it's a book that's a little bit old now, but it's
2003, I think.
2003, but it's a really good place to start if you want something.
Let the land in the front.
Yeah, I'm stopping now. Should we have 5 minutes and then yeah.
Can I go through my kind of summary of the court
Yes.
and the court? So am I right, and please correct me if I'm wrong, at all, that ordinary court, cert court, magistrates court, juvenile court, can appeal, goes to royal court,
Mm-hmm.
royal court, court of appeal, court of appeal.
Yes.
So it was more just the four.
Yeah, yeah. Yeah, yeah.
Did you know whether the ordinary court, like it would be from staff and ordinary?
If they manage to deal with it.
Yeah.
When they don't tend to deal with it, it tends to go. It tends to
I
go.
think technically you can go from the, well, can you go, where would you go from the ordinary court?
From the ordinary court, I think, we need to have a look.
Yeah,
Uh,
yeah.
It might be to the full court.
All right, so yeah, we'll check
I'll
that.
have a look at that. But because in practice they don't tend to deal with the child
No.
readiness stuff, they either goes across to magistrates court